ruling will be available after this. Upon perusing the notice of motion, application dated 12th October by the applicant, Party of National Unity, and noting the applicant's filed submissions, also noting the opposition of the 7th, 8th, 9th, 13th, and 18th respondents, and considering all arguments and the law as set out in the Trusted Society of Human Rights Alliance and Mumo Matemu, and also in the case of Francis Muruatetu and others, we find that the applicant has not met the threshold for admission as an interested party, as it has failed to establish a personal interest or stake that is proximate enough to occasion any prejudice to it if not enjoined in these proceedings. We therefore find no merit in the application, and we accordingly dismiss it. There shall be no order as to cost.
Thank you, Honorable the Justice Njoki Ndung'u, for delivering that decision on behalf of the court. I will now request the Honorable Mr. Justice Renaura, Supreme Court Judge, to read the court's decision on the joinder of amici curiae.
Thank you very much, Chief Justice. The first ruling is by the first application is by Professors Rosalind Dixon, Professor David E. Lando, and Professor Gautam Bhatia. All the applicants seek to be admitted as amici curiae in petition number E016 of 2021. We have perused the affidavit in support, the submissions by the applicants, their reliance on the case of Trusted Society of Human Rights versus Mumo Matemu, and Raila Odinga and others versus IEBC. We have considered the grounds of opposition by the 20th and 23rd respondents. We have looked at the law in Rule 19 of the Supreme Court rules, the case of Trusted Society of Human Rights Alliance versus Mumo Matemu, and Francis Kariuki Muruatetu and another. We are not convinced by the arguments against the admission by the 20th and 23rd respondents. We see no evidence of bias, of lack of neutrality, and therefore, having considered the application against the rules and the law, we make the following orders. The motion dated 1st October 2021 and lodged on 4th October 2021 by the intended amici curiae is allowed. And this is important. The amici briefs attached to the application are deemed as filed, and the applicants shall not make oral submissions at the hearing of the petitions. Parties shall bear their own costs. The second ruling is on the application of Professor Migai Akech to be admitted as amicus curiae. We have looked at Rule 3, 19 to 31 and 50 of the rules, the practice directions of the court. We have considered the grounds in support of the application, the reliance on the case of Trusted Society of Human Rights Alliance versus Mumo Matemu. There is no opposition to the application. Having considered it, we are also of the view that Professor Migai Akech, in his brief, will be of valuable assistance to the court, and we have seen that he has demonstrated expertise in his field relevant to the proceedings before the court. In the circumstances, the application dated 20th October 2021 and lodged on 22nd October 2021 by the intended amicus curiae is allowed. The amicus brief attached to the application is deemed as filed, and the applicant shall not make oral submissions at the hearing of the petitions. Parties shall bear their own costs. The third application is by Professor Richard Albert and Professor Yaniv Rosnai. They have relied on the rules 3, 19.1, 31, and 50 of the rules. We have considered the grounds on the face of the application. We have read the amici briefs by both Professor Richard Albert and Yaniv Rosnai. Their reliance on Francis Kariuki Muruatetu and Trusted Society of Human Rights Alliance. We have looked at Rules 19 of the court rules, and the two decisions I've just quoted above. We have seen that the applicants intend to address the court on the issue of constitutional amendments, relevant, including questions touching on the basic structure, its scope, relevance, and applicability. In the circumstances, we are of the view that the applicants' very detailed amici briefs shall be useful to the court, and therefore we shall allow the application to be admitted as amici curiae. The amici briefs are deemed as filed, and the applicants shall not make oral submissions at the hearing of the petitions. Parties shall bear their own costs. The fourth and last application for admission as amici are by by Professor Charles Fombad and Professor Adem K. Abebe. They have relied on Articles 1, 2, 3, 10, 48, 159, 160, 164, and 259 of the Constitution, and Rules 19, 1 and 2 of the Supreme Court rules, as well as the affidavit sworn by Sally Omoto, advocate. We have looked at the amici briefs. They have detailed a number of questions for Professor Fombad. He has asked 3 questions that he wishes to address, and Professor Debe has similarly raised 3 questions which he wishes to address. Having looked at the law, Rules 19 of our rules, the cases of Raila Odinga and others versus IEBC, Trusted Society of Human Rights versus Momo Matemu, we are of the view that the admission of the amici curiae will be useful in achieving our mandate to develop the law with the assistance of input from parties appearing before us. And we find that the amici have filed a detailed brief which shall be of use to the court, and therefore we shall admit their application, we shall allow the application, admit them as amici curiae. The briefs attached to the application are deemed as filed, and the applicants shall not make oral submissions at the hearing of the petitions. Each party shall bear their own cost. Thank you, Honorable Chief Justice. Thank you, judges. Thank you, Counsel.
Thank you, my Lord, Justice Renaura, for delivering the 4 rulings on behalf of the court. I will now ask the Honorable Mr. Justice Ouko, Supreme Court Judge, to read the ruling on the application for consolidation.
Thank you, my Lady Chief Justice. It's a straightforward application. It's brought by way of notice of motion by Dr. Duncan Oburo Juang, Dr. John Osogo Ambani, Dr. Linda Musumba, who are seeking leave to consolidate petition numbers 11, 12, and 13 of 2021. Upon perusal of the affidavit of Duncan Oburu Ojuang, and upon perusal of the response by those parties who have filed their submissions in this application, which is essentially not opposed, and being guided by this court's decision in the case of Law Society of Kenya versus Center for Human Rights and Democracy and 12 others, and considering the provisions of Rule 12 of this court's rules, we have no doubt that the application meets the threshold for consolidation. We further find that petition number 12 of 2021, the Attorney General versus David Day and 73 others, encapsulates most of the key grounds common to the rest of the other petitions, in contrast with the appellant's petition number 11 of 2021, which raises a single issue. The order of proceeding of President's proceedings and presentation will be shortly given by the presiding Chief Justice, but we make the following orders in regard to this application. Number 1, that petition number 11 of 2021, Murara Amoke versus His Excellency Uhuru Muigai Kenyatta and 83 others. Petition number 12 of 2021, the Attorney General versus David Ndei and 73 others. And petition number 13 of 2021, IEBC versus David Ndei and 81 others are hereby consolidated. Petition number 12 of 2021, the Attorney General versus David Ndei and 73 others will serve as the lead file in the proceedings, save to add that they will need to add all the parties that are omitted. For instance, Mr. Ochiel's clients, Dr. Mwimali and Muhuri, and any other that may have been omitted. Those are the orders of this court. Thank you, my lady CJ.
Thank you, my Lord Justice Ouko, for delivering the ruling on behalf of the court. Having delivered the 7 interlocutory rulings arising from the 7 interlocutory applications, the 3 petitions are now consolidated, and the read file is petition number 12. We will now proceed to give directions for the hearing of the petitions as consolidated. In light of the above decisions, the directions of this court with regard to disposal of the consolidated petitions are that petition number 12 will be the read file. The petitioners in the 3 respective petitions will be the appellants, while the rest will be the respondents. At our preliminary review of the record, we have been able to discern some issues which will guide counsel on the filing of the submissions, and I will request my brother, the Honorable Mr. Justice Ibrahim, to read those issues. I also wish to hand, if any party feels at liberty to hand another issue, they can do so.
Thank you, my Lord, the Honorable Chief Justice and President of the Court. The Court has considered, having read the record thoroughly, the issues raised in the petitions. 3 petitions were lodged in the Supreme Court, challenging the judgment of the Court of Appeal in Civil Appeal number E291 of 2021 as consolidated with E292, E293, and E294 of 2021, delivered on 20th of August 2021. A summary of the issues raised in each petition is set out herein below. 1. The basic structure doctrine is whether the basic structure doctrine is applicable in Kenya. If so, the extent of its application, whether the basic structure of the Constitution can only be altered through the primary constituent power, and what constitutes as the primary constituent power. This emanates from the petition by the Attorney General. 2, whether the President can initiate changes and or amendments to the Constitution, and whether a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 of the